So I want to go ahead and get started because I have two different documents that I want to go over today. And both of these documents have to do with possession. So the first document that we're going to look at, this one's actually provided by the Heart of Kentucky Realtor Association, and this is a early possession agreement. So this means that for whatever reason, the buyer is moving into the home prior to actually closing and owning the home. That is not something that I recommend. There's a lot of liability as well as legality and potential things that could go wrong. However, in some unique circumstances, this does make sense for all parties. And ultimately, what any buyer and seller wants to do is what we need to try to facilitate. So I wanted to run through this document before we get started on it. I wanted to let you know when I email out this, I did draft up the key concepts, like what is the early possession agreement, what are the key concepts that you need to understand, including instructions on how to fill out each section, as well as some additional notes. And we do have that both for the early possession as well as the delayed possession, which is going to be the second agreement that I go over. But with that being said, let's go ahead and dive into the first agreement. So the top part, of course, this is just what you're going to fill out for the contract. So what's the date of the contract? Who is the contract between? The buyers being the top line, sellers being the next line, and then the property address below that. Next, we have the date to take possession. So it says here the buyer shall be allowed to occupy the property beginning on blank day. So for example, December 21st, 2024. In consideration for the seller's permission to do so, the buyer shall pay a deposit of blank. So this is how much of a deposit, just like if they were to rent any other home, they're going to pay a deposit and then they're going to pay a rent. So these two lines clarify that. Now, one thing I wanted to note on here, make sure if you use this form that everybody's aware of, it says the seller will pay a deposit of blank to be credited to the buyers at closing of the sale of the property. So that means that the buyer is not going to get the deposit back. Like the seller's not going to actually write the check back. They're going to get it towards their proceeds at closing unless you change this document. Keep in mind, anytime that you change a document, you would basically cross through this and say, you cross through the credited to buyers credited to buyers at closing of the sale of the property. All parties would initial data, and you would put what would happen. Like, so for example, if they actually wanted to return it and they didn't want it to be part of closing, then they would cross through that, write in what they wanted it to be, and then initial next to it. Also, it says the next part is the rent. So the buyers shall pay blank for each day starting after the first day of possession. So this is broke down to a daily rate, which means if they're taking possession of the property prior to closing, they will need to pay rent for that. And then here it says this amount to be paid, and you would circle one of these. So either daily, weekly, or at closing. Next is consequences for what happens if it doesn't close and the buyer doesn't vacate the property. So here it says that the property does not close by, and you insert a date. Buyer shall vacate the property and remove all of their personal property as of this date. All proceeds paid will be forfeited by the buyer to the seller, which means the deposit, any rent, they do not get that money back. From each day the buyer does not vacate the property after closing date, the buyer shall pay the seller blank per day until the buyer vacated the property of all personal possessions that were in the premises by buyer they were put in the premises prior to buyer closing date. So what that basically means is it's not only they have to be out, but all of their possessions need to be out, which means if they were happen to leave something behind, a TV stand and a TV, they have not vacated the property. That buyer would still be subject to this penalty per day until they get everything out. This is a really important part, and I think this is important whether you do a early possession or a post possession. But it says buyer further agrees to furnish a copy of renter's insurance policy on said property and release seller from any and all liability that may result in early possession. So this is really important because no matter which side you're on, early or delayed possession, the the current owner, in this case being the seller's, insurance does not cover the buyer's property. So if the buyer moves in early and heaven forbid something were to happen and there's a fire and the house gets damaged and the buyer's personal property gets damaged, that's not going to be covered under the seller's insurance because it's not the seller's property. So that's why a rental agreement is so important. On the flip side of that, just so you know, when we get to the delayed possession agreement, same thing. Like, I think the seller should have a rental policy because now the buyer's insurance has taken over. The sellers have canceled their insurance. They don't own the home anymore. They still have their property in it. If something disastrous were to happen, the buyer's insurance is not going to cover that seller's property. So just know, big fan of renter's insurance. It's not very expensive, like 10 to 15 bucks a month. Could have gone up. It's been a while since I've gotten a policy on that, but it's definitely worth the money. Also, it says the buyer is to agree the property is in condition, in its present condition, except noted as below. So if there's damage to the property, they would note this here. So if there's damage to the walls, you would want to note that because and I would recommend, by the way, take pictures. Have your clients take pictures of all damage before they move in. That way they can take pictures of everything once they move their stuff out and prove they did not cause any new damage. Remember, you either have documentation or you're probably going to be held liable. So just keep that in mind when it comes to anything. All right. It also says that this whole part is about what happens if one party doesn't do what they say they're going to do. It does say that the buyers would be responsible for the seller's closing costs if the seller had to basically take it to court to get possession of the property back. That's another reason I don't really like the early possession. If somebody doesn't do what they say they're going to do, it's going to go to court. Even if our contracts, and this is important to note, even though some of our contracts talk about that mediation occurs before courts get involved, this clearly states down here that this right here, all parties agree that the agreement shall be enforced in a court of law, including through action of forcible detainer, regardless of what the contract says about resolving disputes. So because we're stepping into rental agreements now, and basically we're, for all intents and purposes, doing an eviction at this point, the courts come into play. Mediation is now thrown out and we're going straight to court. So this is just an important thing for you to know. Also says that no verbal agreements are allowed. Everything is documented. Basically, if it's not in this total agreement and the buyer and sellers have a handshake agreement that they can keep it for an extra 30 days that isn't recorded on this, that does not matter. If it comes to the court of law, that's going to be thrown out. It's not going to count. All agreements have to be in writing. So just keep that in mind. Time is of the essence in respect to this agreement. This is important to note on all contracts. If it doesn't say time is of the essence, then that means as long as both parties are diligently moving forward to a conclusion or to a closing or to whatever the action item is, then the agreement still stands. If it says is of the essence, then the exact date matters. Meaning you can't go 1 minute past 1 second past whatever date it says that something needs to happen. Time is of the essence. It basically on that date, it ends or begins and there is no continuation. Versus a contract that doesn't say time is of the essence. And FYI, for our Owensboro people that are watching, our purchase agreements do not say time is of the essence. So if you need hard dates inside of there, make sure you write that in the further conditions. Holler at me if you need some help with that. Also, in this bottom agreement, this bottom paragraph just says that both parties have negotiated, and it's at the mutual benefit between both parties. Also, both parties have been encouraged to seek counsel since they're signing legally binding documents, and also says that everybody intends to abide by what this contract says. Again, I know I went through that pretty quick, but it's a simple document for a complex issue, if that makes sense. Again, we will email out the summary that I drafted of what it is, the key concepts that you need to know, as well as instructions for how to complete it, and then some legal, just additional notes as well. So that's the early possession agreement. There's one other form that you might use, depending on which brokerage and board that you're part of, and that is the delayed possession agreement. Again, on this one, I also have all the summary, the key concepts, and the instructions that will be emailed out to you a little later today. But I wanted to talk through this agreement because while they're similar, they have subtle differences. In addition to, this is obviously the seller staying in the home until the buyer takes possession, which is really common in our part of the country and in our state. So to fill this out, it's, all the same contract stuff. What's the contract date? Who's the buyer? Who's the seller? What's the address? this is really one thing that's slightly different is in paragraph number 3 here, it says the contract either did, and you would check this or put an X, did or did not provide the seller would be allowed to retain the possession for X number of days following closing. So a lot of times in our contract, we write that out. Seller to possession to be 14 days after closing with signing of the deed, for example. It is now therefore agreed, so this could be a document that changes that. This is now for agreed that the parties, upon the mutual covenants contained wherein as follows, seller shall be allowed to retain the property until blank. So even if your contract said 14 days, and you need to extend that for whatever reason to, let's just say, 60 days, then you can write that date in, what is 60 days, and this would override what was original in the original contract once everybody signed. Keep in mind, everybody has to sign for it to be an executed contract. It also says the seller shall provide written notice 48 hours in advance of the date and time when the seller will vacate the property. So regardless if they get out this date or they get out earlier than expected, they do need to give 48-hour notice. That way the buyer can make plans to transfer utilities, things like that. And we're going to talk about utilities here in a second. Number 5 is what happens is rent and consequences if people don't follow the contract. So just like the last one, the seller is going to pay blank per day. If the seller holds the property past the vacate date, then the seller now owes the buyer a rate of blank per day. So this is what it's costing to rent. This is what happens if they don't get out by the time that they need to. The recovery of this holdover rate by seller in no way limits buyers' other legal remedies in any way, which basically is saying that if they needed to evict, they can go through the eviction process regardless of what this says, as long as it's post the date that they agreed to in the contract. The next thing talks about the condition as well, and 6 and 7 is conditioning utilities. So the seller must maintain the property in the same condition. They must mow the grass. They must, continue to, and it also states that the seller, while the seller is in possession of the property, if the buyer's insurance refuses to cover insured loss, seller has to compensate the buyer for the loss. So that's a really key thing. I'm kind of just making something crazy up here, but if the seller starts a fire, arson, basically, and the buyer's insurance is like, we're not covering that under insurance because that seller was living there. The seller is part of this contract is responsible for fixing whatever damage is done. And there's a million different ways that can be used. Just wanted to give you one example. Number 7 is they have to maintain utility as long as the property's in the seller's possession, which goes back to the 48 hours in advance notification, because part of that is having time to transfer utilities into the buyer's name, things like that. They'll allow time to be able to move, stuff like that. And then 8 is all about the renter's insurance. So just like I said, I'm not going to re-harp on it. The renter's insurance would be required per this document for the seller while they're maintaining the property until the buyer takes possession. And then this also goes a little further than the early possession document. It says seller shall be responsible for paying the buyer's deductible of blank should a claim be charged. So you would need to go ahead and secure the insurance. The seller would secure the renter's insurance, and then the seller needs to also understand that if there's damage that's done, that they're paying the buyer's deductible, and what is that deductible as well. Again, and then from the next one is the right to inspect the properties. The buyers will have the right to inspect the property at any and all reasonable times, giving sellers 2-hour advance telephonic. I don't even know what word that is. I've never even seen that. Is that telephonic? Basically call from the telephone. Why don't they just put telephone? Anyways, they have to call and give at least 2 hours notice to come and inspect the property, make sure it's not damaged, things like that. This is short notice. Usually for a traditional renter's notice, you get 24 hours notice. So just something to note. And of course, again, you can do above the line changes. Don't recommend it, but you can do above the line changes if you need to change timelines or anything like that. Number 10 is what happens if the seller doesn't get out. This is really, in my mind at least, unless I'm misunderstanding, I don't think I am, 10 is just a repeat of 5. Basically, the second part of 5 where it says seller shall pay a buyer holdover rate of X per day. In the event the seller does not give possession of to the buyer on midnight of blank, seller to pay blank per day as liquid damages during this holdover period. So I guess number 5 would be if they agree that I need to expend it 7 days, here's what I'm going to pay you. Number 10 is we don't agree and you just refuse to move out. What's the charge for that? So I guess it is slightly different. Number 11 is just, again, all about attorney costs. It says that all parties understand this is enforceable by court of law, including through the forcible detainer, regardless of what the contract says. So again, it goes back, if your contract says mediation, this allows it to jump straight to court because, again, you're basically evicting somebody at this point. And then page 2, like I said, this one's a little bit more detailed. This is all about payments. How will payments be made? This is important to note. Maybe this is why it's important to read your contracts. This says that the buyers will pay the amount by depositing a check for that amount by regular first-class mail on Friday during the week which the seller retains possession. The final payment for any partial week shall be made at the date possession is returned at closing. So, per this contract, if the seller hands the buyer cash, we are in violation of this contract. And that's what I want y'all to understand. It says that it has to be by a check and depositing it by and received by first class mail on each Friday. So it's very specific on how this has to happen. Again, just one of those things, you might need to change that based on what the buyer and seller agreed to. This agreement is the amendment of the modification of the original sales contract, and all terms shall survive closing. So that just means this, no matter how long this takes to transfer this possession, this contract is in full effect. Again, the no verbal understandings is 14, and everybody understands that it has to be written, no handshake agreements. If they handshake agree to pay cash in rent, but this says check, and there's a dispute that comes up, that cash payment is not part of this contract. It is outside of the contract. Somebody has violated the contract, just to kind of reinforce that. Number 15, it just says again that all parties have been let known to seek the benefit of assistance of counsel, because this is a legal binding document, and that I do like this, that it does say that this document is construed in favor of neither the buyer or seller. It's mutually beneficial. And then number 16 is if something does happen, it's not the realtor's fault, it's not the brokerage's fault, it's not the MLS's fault. This is an agreement between a buyer and a seller, and you can't hold us basically in penalty or hard or sue us over somebody not following the contract, because most of the time, especially not necessarily on the delayed possession agreement, but on the early possession, we're going to be discouraging that because we understand all of the liabilities and everything for that. So that's the two I wanted to go over. I know this happens a lot, not necessarily the early possession, but the delayed possession. In the Owensboro board, I did look for this type of document and I couldn't find it. So that's why I'm going over HCAR documents. So HCAR agents, you have a heads up. You have some legal protections that are in place and ways to get your clients compensated should this need to happen if you're representing the seller. And then for Owensboro agents, I'm going to be asking the board if they have any documents that are similar to this, or if they could maybe create something for us, and I'll let you all know once I have that. But those are the two documents that I wanted to go over. So I'll turn it over. I'm going to stop my recording real quick, and then I'll see if any of you all have questions. And if not, we will wrap